now let's talk about an unmarried person with no child or descendant. So let's say that you have an unmarried person. So that person does not have children as well. So they have no spouse and no child. So again, we go with the moiety system. And if we can't go down because there's no children, we go up. So one half would go to parent one half would go to parent number two. If the decedent is survived by one parent and has siblings or descendants of siblings. So it attempted to go down, couldn't go down, went up, only one half of the parents are available. So one parent is surviving. Then that second half will go to the siblings equally or the descendants of siblings. So nieces, nephews, and further down from there. Let's say the decedent is survived by one parent, but either has no siblings or their siblings have passed and the siblings had no descendants. So you had an aunt or uncle, they passed, and they didn't have any children. Then 100% will go to that surviving parent. So it's just like the previous rule that we talked about.
Right.
Now, let's say that neither parent is around. So it went down, nobody down, went up to parents aren't around, then it goes out. And so then 100% will go to the siblings or those descendants of the deceased siblings. So it'll go up and over to your siblings. So your brother or sister would be the one that would inherit. If they predeceased you, then their children, so nieces and nephews. And again, all these scenarios apply if and only if you don't have a will. So if you have any desire to give to someone that's not one of those family members that we talked about. So maybe you have a really good relationship with a cousin that you treat as if they're a niece or nephew, or you treat as if they're a son or daughter, or you have a child that is a close family friend that's kind of your adoptive child. So in my case, I have a really close family friend and I don't have any children of my own, but I am an adoptive aunt for one of my friend's children because he doesn't have any aunts or uncles. And so in that case, if I were to pass, I would definitely want that child to be able to take a share because I want to, be a good aunt and be able to help take care of him. So in order to do that, because I have not legally adopted this child, it's just kind of an informal relationship, I would need to codify that in a will. And the same is true, like I said, and a lot of times in Hispanic families, you'll have cousin brothers, uncle dads. If you have a situation like that where you want to be able to treat a niece or nephew who doesn't have a father figure in their life as a child, you need to codify that one in a will as well, just because that's not a legally recognized relationship.
So you can get really creative in a will, right? You don't need to follow the local rule. So
correct.
I think this is a misunderstanding. A lot of people think, oh, I don't need a will. I'm still young, right? I'm in my 20s, 30s. Maybe I will think about to have a will when I'm at my 60s, right? But I think in the modern world, that's a misunderstanding. I would say if you don't like the court arrangement, or if you have someone special but who is not related to you, and then you want that person to be benefit if anything happened to you, you need a will. Maybe start drafting a will or thinking about a will today. And I also want to talk about a special family, like for example, the blended family, or a couple that stay in the marriage for the children because they don't really want to they don't have a really good relationship, but they don't want to get divorced. They're staying together for the children. So those families especially those families, you might want to have another arrangement because you would think that the local law is not going to be the best arrangement for your situation.
Correct. Now, and something to point out, we talked about blended families earlier. When I said that all children they're all of your natural born children. So let's say that you came into a marriage and you have stepchildren. According to the intestacy laws of the state of Texas, stepchildren never take. So if you have stepchildren that you care about and you like, and you want to be able to take a portion of your property and you want to be able to share it equally, for a lot of people, even if you get children through a marriage, like they're still your children. So if that's something that you want to have happen, you're definitely going to need a will in that situation. We already talked about situations where you have family members that, you have friends or people that wouldn't necessarily be in your natural family that you have informally adopted without adopting on paper. If you do formally adopt a child in the state of Texas, or even an adult in the state of Texas, the person that is the adoptee has the choice to inherit from either the adoptive parents or their actual parents. They get to pick only one through intestacy. So as I've said, these are kind of just a quick rundown of some of the weird and exciting laws in the state of Texas as far as intestacy is concerned. So if you have any questions, if you want to walk through a scenario with us, you can go ahead and contact us. And if you would like to look at the possibility of creating a will that has a different scenario, we're more than happy to hear from you. And we would love to be able to do a design session with you.
Great. Thank you so much, Katie. See you guys next time. If you like the video, please give us a thumbs up and subscribe our channel so you won't miss any single videos. And we'll talk to you next time.
All right. See you next week.